Now let's start the proceedings of the court, and in that proceeding I request our deputy convener to escort our president of the Moot Tribunal. सर ये हमारी परंपरा है छोटी सी I request second judicial member Kumarji Bhatt, please join.
The most efficient person I know in the bar is Kumarji Bhatt.
I request third judicial member.
Don't say there वो एक से बड़े दुख हैं कि देर के दो ने.
गवर्नमेंट काउंसिल चेंज करना.
हमारे कैपिटल कह रही हैं जी गवर्नमेंट काउंसिल चेंज होनी चाहिए.
गवर्नमेंट काउंसिल तो कभी चेंज नहीं होंगे, सॉरी.
पता नहीं कहाँ से लाएगा.
ये मोटी गवर्नमेंट काउंसिल.
Before we start, I request each and everyone. I request Registrar CA Renu Sharma ji to take her seat. May we proceed, sir?
For the Saturday today, first is the measures AK Trading Private Limited versus Commissioner State Goods and Service Tax. The matter will be represented by CA Akash Srivatsan Raghavan, who is travelling from Bangalore here, specifically for this case. SU sir will appear as a government counsel today. And the brief issue of the case is the appeal concerns the cancellation of registration due to failure to maintain proper books of accounts. So please Akash come.
Order has travelled beyond the underlying proceedings, my lord, which arises from impugned OIO, which has been passed ex parte, which arises from impugned SCN, which alleges three aspects, my lord. First thing is regarding non-filing of returns for a continuous period of 6 months, my lord. It's the appellant's position that even before the date of OIO, in our submissions, we have clearly laid down that all the returns defects have been cured before the impugned order has passed, my lord. Regarding the books of accounts, it is the appellant's position, first of all, that this is not proceedings under section 65, my lord. Without prejudice to this fact, the appellant has in fact maintained the books of accounts, and under allied laws, under Companies Act, AOC 4 has been filed from 1st April 2018 till 24/25. A copy has been annexed where the appellant's authorized signatory has signed, my lord. Further, there has not been any nullified, there has been retrospective cancel of registration, my lord. No nullified has been imputed, nor any effort made either under section 62, better assessment, or any other provisions of GST law to establish from the first month to 7th month that there has been any nullified. Rather, registration has been ab initio been cancelled, my lord. The impact, rather the issues I would like to pose, my lord, is that because of these implications, the ITC of the appellant, the closing balance, will lapse, my lord, which was as on 1st September, which is date of suspension of registration, my lord, will lapse. Secondly, under section 16(6) of CGST Act or SGST Act, my lord, appellants eligible for ITC if my lords allows the appeal, my lord. So that will again lapse, my lord, for the period after suspension till the present date, my lord. When moreover, in PMT 6, my lord, which is the challan, appellants have been paying taxes. Appellants are not allowed to only file returns because of suspension or issue tax invoice or collect tax, my lord. However, we have been paying taxes in PMT 6 for the transaction entered, my lord. Those taxes will lapse, my lord, if it is not allowed. More so, appellants have customers who are government contractors, my lord. So the age of the registration has great implications on winning tenders, my lord. Therefore, restoration of same registration is something which the appellant pleads, my lord. And lastly, this amounts retrospective cancellation from 1st April 2018, my lord, which impacts even the customers, where I said nullified has neither been proved on the appellant nor on the customers from retrospective date, my lord. Therefore, it is a prayer of appellant, my lord, that the registration is restored from the date of cancellation, 1st April 2018, so that appellants can enjoy the fundamental rights as well as the legal rights under GST and allied laws due to restoration of the registration, my lord. That's the prayer of us.
Where is the show cause notice? Does it mention anywhere that the authority proposed to cancel your registration with retrospective effect?
Yes, my lord. It did.
It is there.
Yes, my lord. And we have filed our responses even before the date of impugned order, my lord, wherein all the returns have been filed and reply has been given, but no personal hearing was done.
The inspector has visited your premises twice.
Yes.
You have not responded.
My lord, we have responded, my lord. The only thing is the communication of the order which has been stated, my lord, has happened only on 16th of October, my lord, because the authorized signatory, MD and CFO of the company was travelling, who takes the decisions in the organization, my lord. The receipt to him was only happened on 16th of October, my lord. Immediately all returns were filed on the GST portal. So respondents were made aware GST portal ab initio, my lord. Secondly, on 16th or 17th of October itself, the reply was filed online, my lord. On the 18th, when in fact the appellant has visited the respondent's premises to submit the hard copy, which acknowledgement has been given as an office, my lord, that is the time when they were communicated about input order, my lord. So before communication itself, all the submissions have been made and the defects have been cured, my lord. Therefore, under Rule 21A4, my lord, and 22A, such revocation should have suspension as well as cancellation is what is the prayer, my lord.
You have filed an appeal
Yes.
against that order.
Yes, my lord.
But you have not filed the grounds which you had filed appeal, first appeal. The grounds which you filed are the main contents. You have not enclosed them.
Annex, my lord. It is annex, my lord. In the yes, my lord. Yes. It's in the. It's in page number 121 to 130, my lord.
Page
121 to 130, where all the grounds have been taken.
Now, Your Honor, the question is, GST law is not concerned with what happens to its business. We are keen to collect revenue, but in accordance with law. If Your Honor sees the show cause notice of 1st September 25, it rightly says under 29.2, I propose to cancel your petition as suo motu with effect from 1/4/18. Whereas your business premises are tenanted premises as the above address without any godown or warehouse as per record from the portal. Whereas on 1/9/25 you have not filed returns for last 7 months, and in spite of inspector's visits, returns have not been filed. These findings are not challenged and this is not rebutted. Further, the inspector who visited your business premises 2 times on 4/8/22, as the Honorable Judicial Member pointed out, and met your partner Shri S.K. Malhotra, who signed the reports, also found that there were no books of accounts being maintained by you and stock could not be compared with your books of account. This is a very serious violation. Also, when you were called on 24th August 25 to produce books of accounts, you chose not to appear. He is talking of section 65. 65 has no relevance in section 29. 29 is an independent section. 65 deals with audit. We are not doing this audit. We are not even assessing him. And 62. Section 62, my friend, is for assessment of non-filer of returns. That stands on a different footing than your case. Right? So 62 is not relevant here. Under circumstances, I am convinced that you have been willfully violating the statutory provision, not only by not filing the true and valid returns and paying taxes, but also it seems you are manipulating books of accounts or not maintaining the books of accounts. You are therefore directed to show cause as to why your certificate will be cancelled with effect from 1/4/18 under 29.2, Red Rule 21, and your reply must be filed within 15 days. No reply was filed. A reminder was sent on 17/9/25 to ensure that he dealt with in accordance with law. And this also says, whereas a show cause notice in the prescribed form RG70 was issued so and so, has been served on your partner S.K. Malhotra, and you were called upon to show cause on the issue raised so and so, so and so. There are reports that you are still conducting business Even when RC was suspended, he was still conducting his business, which is completely illegal. He cannot collect tax. He cannot make taxable sales after RC is suspended. It's not possible. You are once again directed to do the needful in terms of show cause notice so and so, and file your reply by 39 positively, without which your still certificate may be cancelled in terms of particular so and so. Now, the adjudication order passed on 1710. Till 1710, we have no reply.
But the same day he has filed the reply.
No.
My lord, returns were filed on 16th on the portal, my lord, which the respondent would have been aware of because it's an online portal. Reply was filed online on 17th. Yes, my lord.
17th October he has filed the reply.
Wait, sir. We'll come on that issue. But let us say this proper officer order of 17th October, para 4. Further, the inspector who visited your business premises 2 times on 4, 8 and 28, there were no books of accounts. And then the findings operating para is, in spite of many opportunities given to you in writing by issuing and serving the notices on you, you have failed to show cause in terms of SCN dated so and so. Admittedly, you have failed to file returns for 7 months as on 1st 9/25. He says he filed the return on 1710. How can this order be incorrect?
16, he says 16.
No, as on 1st 9/25,
Yes.
right? And also, you also not produced books of account in spite of opportunity given to you. It's clear that you have willfully violated so and so and so. Let's come to appeal, where I am more concerned. What he writes in the appeal, grounds of appeal, and what he has stated in appeal. The appellant, this page 29. Page 29 of appeal, sir. This is paper to be given today. Page 29.
RG 90?
Yeah, on page 19. Open that. Know this.
Page 29.
Page 29. I'm going to read page 30. Page 30. Third paragraph. When questioned why the proceedings before proper officer were not attended, the counsel pleaded that the paper were given to his office, but the staff did not bring the same to his notice. This is the ground taken in before appellate authority. Hence, there is no fault of the appellant. The explanation is accepted without an affidavit. But what he writes in appeal is a totally different story. Hence, there is no fault. The explanation is accepted on the fact of it, as the counsel himself admitted the same, even though no affidavit has been filed. The counsel has stated that 3 returns had been filed on the date of cancellation and 4 returns were remaining and are still remaining. This is before appellate authority, so all returns were not filed. 3 were filed before appellate authority. Further, 3 returns had become due for which the appellant had no answer. Notwithstanding the situation of the appellant, the law has to be enforced on this issue. No other argument was put forward by the counsel, and hence on this court the order of the proper officer is upheld. On the question of non-maintenance of books of accounts, no answer from the partner S.K. Malhotra, the counsel could not give any satisfactory reply at all. In my view, these are serious violations of law, not filing return, non-maintenance of books of accounts, and no satisfactory explanation coming forward to consider any relief for the appellant. Hence, the appeal is devoid of any merit. Let's see his appeal now. I will not read the entire page, Your Honor. Statement of facts. He says reply to statement of facts on page 7, Your Honor. Page 7. Page 7. Original proceedings were initiated that detailed in so and so. Notice of 1st September and GST certificate suspended from said date. So once it was suspended, how are you doing business? Under what authority of law?
But the department has not put any record. How they have come to know that he is doing business?
There's a report. There's an inspector's report.
Their report does not carry weight unless they put some documents. Somebody has visited his place. Then he should have...
Your Honor, definitely. Once there was an allegation, they were to rebut.
Another question is, before the inspector visited their premises, was any notice issued to them that he would be visiting on such and such?
Yeah, it's always done nowadays. It's always done.
No, was it done in this case also?
No, but in this case, there is no allegation. There is nothing they have said.
My lord, rather the appellant has questioned in the appeal, my lord, the section under which underlying proceedings were invoked, but we are writ large in front of the OIA, my lord. So therefore, there has been a question raised in the preliminary objections to say that the appellant was not even aware which section under which the proceedings were raised, my lord. No notice, no proceedings. Straight away there's a field verification on the appellant's business premises.
My lord will answer it. We'll answer this question, what is raised. Now, he said this reply was filed on 17th October, which he was supposed to file by 24th.
One more. Whether any notice was given to him before suspension?
Yeah, it was there, Shoka's notice. Yes, it was there. We gave notice.
After this cancellation notice was given, then suspension was made?
Yes, it was given. It was given. Now let's say further.
Just let him.
Let us go to page 10. Para 2. Impugned order is bad in law insofar as it arises from improper adjudication proceeding with no valid communication of impugned SCN or an appellant. Now this is no way this can be written.
What is your reading?
Sir, on page, I think it's page 16, handwritten page 16. Yeah, it typed 10 but handwritten 16.
16 is running page. Yes, always refer to running pages.
You got it, man?
Yeah.
Impugned order is bad in law insofar as it arises from improper adjudication proceeding with no valid communication of impugned SCN or an appellant. It was served on your partner. How can you write this kind of a ground? Ask Malhotra is your partner. Upon verification premises, impugned SCN was updated online without satisfying requirements under section 169. 169 deals with service. The first part is service on portal. The mode of service not commensurate as respondents were aware during field visit that MD and CFO appellant were travelling abroad. No, we were not aware. It was not a part of any record. Now, first he says that the papers are given to him, it's his fault in appeal. Now, in ground says that वो बाहर थे वो लोग, MD बाहर था, सब लोग बाहर थे. The mode confirming demand in impugned order. Salento on this aspect raised in memorandum to FAA makes entire redressal an empty formality for this reason. Now this is a false ground. This is not acceptable to revenue. Then you want to come to page 17. The appellant writes, without invoking section 62 directly, cancelling certificate shows.
Which pair are you reading?
Para 4, sir. Last 5 lines. Without invoking section 62 directly, cancelling certificate, predetermined intent of respondent. Well, 29 is not dependent on section 62. There is no way. We will read 29. It has no implication. Now, on page 18, we are discussing law. This case can be decided in 1 minute. We are also discussing law so that all of you learn. Last 4 lines, without establishing burden about which clause under Rule 21 has been contravened, appellant and makes redressal at appellant forum an empty formality. He has mentioned all what was required in the grounds. So non-mentioning a particular sub-clause is not fatal to the appellant's jurisprudence. Then he says, para 7, appellant has filed reply to impugned SCN on 1710. Supposing it's 1710 filed at 10 p.m.
Whenever you refer to a para, please tell us the line also which you are reading.
I'm reading line 3. Appellant had filed reply to impugned SCN on 17th October. He was supposed to file by 24th September. He was given time, he did not. And supposing on 17th October he filed in the night at 11:30 p.m. So will the officer open portal? He was under duty to inform. Since you have not passed the OIO, we have filed the reply, please consider. Since you have not passed the order on the due date, which was given to me, You have waited for 15 days, wait until the file may apply. He did not. So therefore, on these issues, a story has been made now, that partners were out, still there is nothing available on record, that why were the books not maintained at the time when 2 physical visits were made. And
Was he asked to produce the books of accounts?
yes,
No, subsequently, was it given to him that
yes, it's part of the notice. His RC was cancelled because he did not produce books of accounts.
at the time of visit he did not produce?
अरे शो का नोटिस के बाद भी इसने नहीं प्रोड्यूस किया, वो तभी नहीं किया.
Let him first finish his stand.
Yes.
You answer to me.
Now, just see page 35 reminder.
Tell us one thing, have you filed all the returns by now?
Yes, madam. It was filed even before the.
Now, all the returns have you filed? You have filed 3 returns.
No, sir.
Balance for you have
All
filed.
7 has been filed.
Your appeal doesn't mention?
Sir, my lord, in the paper book, page number 120, my lord, we have annexed a copy of GST.
No paper book. Where is your ground?
Sir,
Paper book is not your
no,
ground.
sir, in the facts we have mentioned, sir.
No, facts also I don't think you have
Yes, sir.
mentioned.
I'll show you, sir.
I don't think facts you have
And
mentioned.
the affidavit, sir. Both the places we have mentioned, sir. I'll tell you, sir.
Has it mentioned? Sir?
Yes, sir.
Okay.
I'll tell you, sir. Para number 7 of the affidavit, sir. Page number 5.
Affidavit or grounds?
Ground also is mentioned, sir, but affidavit we have.
No, where is the ground? Affidavit not ground.
Ground can
ग्राउंड में कहाँ लिखा? पैरा 7 में लिखा कुछ आपने?
Yes, sir. I'll just tell you. One second.
कहीं कहाँ लिखा?
So it is better to get him inside the GST circle so that he does business but with a rider that he should do genuine business.
Your Honor, I agree with you. Let him file all the returns within time given and also produce complete books of accounts within the due time
Yes.
for verification.
My lord, on the books of accounts, my lord, AOC 4 has been submitted 24/25. If at all there is a default of the appellant, there has been severe actions under allied laws, my lord. A copy of
There is no
AOC.
question of any audit report is not a books of accounts.
We said under GST you have to produce,
We
you
have-
have to maintain your books of accounts.
Yes, but we are
at
given
the head
it.
office.
We
So
are
if you don't maintain the books of accounts, it's a serious offence.
My lord, we have maintained the books of account, my lord. The only question about section 65 is that the respondents could not have entered was the only point, my lord. We didn't say that we main books of account has been maintained.
How is 65 relevant?
Sir.
You please enlighten me.
Sir,
65 deals with audit.
Sir, our contention is that.
No, 65 deals with audit, no?
Correct, sir.
Then how is it 29 to
Sir,
concern with
if at
65?
all- Sir, if at all revenue wanted
No,
to-
not if at all. How is 29 concerned with 65?
Books of account, there is under Rule 21, my lord, there is no contravention of books of accounts under 29 to read with Rule 21.
No, 29 says contravention of any rule of law, act or rule.
Yes, sir.
So,
That is.
not maintaining books of accounts is a contravention of law.
Sir.
65 has no concern with 29.
Sir, the
That
con-
means you say that till 65 notice come, RC can be cancelled.
Sir, no, sir. If I can, sir.
Huh?
If I can, my lord. My lord, I agree with the respondents, my lord, that rule says contraventions of the provisions of the law as prescribed. Prescribed is in Rule 21. Only 6 points what is prescribed, my lord. In Rule 21, books of accounts not maintenance does not warrant retrospect or even cancellation of registration, my lord. Therefore, the only default which falls under Rule 21, my lord, is 7 returns which are filed before the impugned OIO, my lord. Therefore, there is no case.
No. 65 has no consent with 29. 65 comes after your returns have been scrutinized or you are searched. 29 अगर इससे लिंक करेंगे तो किसी का आरसी कभी कैंसिल हो ही नहीं सकता.
Yes, our only point is
Chalo,
demand.
doesn't matter. You got the order. Thank you.
Okay.
Bada.
Much appreciated.
Yes, we are directing them to restore your registration certificate and then subject to this condition that you shall be producing the books of accounts before them within 15 days, and all the returns which are still pending should also be filed within a period of 1 month.
Sure, much obliged.
Well done, Akash. Now, friends, what is law? Questions later. Yes. We are dealing, there are 2 cases of RC cancellation in this background today, because a lot of Delhi does only RC cancellation. I believe there was an officer in section 63 who used to cancel on the same date, and he cancelled on the same day 1300. Commissioner told me yesterday कि उसने 1300 केस एक मतलब सेम डे कैंसिल करके सर्टिफिकेट दे दिए. RC cancellation means your business is facing a death penalty. Your business dies. Right? Here you have Mr. Bhatia who believes in substantial justice. The other judges may not believe in substantial justice. Revenue Counsel also believes in substantial justice. But this was a case with serious offences. Twice they were visited. Partner didn't know where the books of accounts are. In ground of appeal, they made out a false cook and bull story. They were out. The only thing was, when OIO is passed, when he cancels your RC under 29(2) for non-filing of 6 consecutive returns. So even when he issued a show cause notice, at that time there were 10 returns pending. But on the date of cancelling, you have filed 6. So 4 are pending. This provision cannot be invoked. On the date when OIO is issued, at that date 6 returns should be pending. So always keep in mind when this ground is invoked. Now supposing your RC is cancelled. So I made out of this case कि आपकी 4 रिटर्न और पेंडिंग हो गई. अब वो जो पहली 4 रिटर्न में तो ऑर्डर शुड गो, पर आपने अपील फाइल की है. Appellate authority under section 10711 can give you a show cause notice. 4 रिटर्न और क्या बताइए सर, अभी आपके पेंडिंग है. So there you can have a very ticklish case. Can appellate authority step into the shoes of proper officer and say that your RC is still cancelled because you have not filed 8 returns now? That's why this appeal was made, and this is valid ground. Because in show cause notice, he can issue a show cause notice, but now you have to know the law. Show cause notice in relation to section 73-74, not in relation to section 29. Therefore, the assertion of appellate authority in this order was illegal. He cannot issue a show cause notice on the returns. He cannot give directions. He cannot remand. Therefore, his only issue was, notwithstanding whatever was asked, were my returns pending 6 returns when OIA of 17th October was issued. Right? And this is your mistake. हमने पोर्टल में डाला था. Please never do it. You have to put officer to notice. Officer, अरे वो आपका नौकर नहीं है, वो सारे दिन पोर्टल देखता रहेगा आपका. So always, Supreme Court is clear. It's your duty to inform the officer that you have done this. 17/10 को उसने 24/9 में डाला था. Why should he wait for you? Why should he see your portal?
Order to 17/10 को pass.
Right, sir. Right. So if you had filed on 17/10 and till then order was not passed, you should have gone in, sir, I filed the returns. Don't take the trouble. Right? This is not a case of section 161. इसका rectification नहीं हो सकता. So whenever you have faced this situation, always go and tell your proper officer, sir, this is what we have done. These are pending. We are going to do it. No proper officer will cancel your RC. उसको cancel करने का कोई फायदा नहीं मिलने वाला. Books of accounts आपका कोई justification आपने नहीं दिया. ये RC cancellation में आपको benefit मिल सकता है. किसी और केस में benefit आपको नहीं मिल सकता. There are judgments all against you completely. Books of accounts, audit report, it has no value in GST. किसी CA की, किसी वकील की, it has no value. Otherwise 73-74 will not exist, no? अगर audit report sacrosanct हो, तो फिर तो free settlement की जरूरत नहीं है. So, still there are a lot of deficiencies in your appeal because your grounds were not tenable with what reply you filed with before the appeal. So little learning, but well done. Thank you.
Proper officer.
खड़े हो गए सर?
Sorry.
You are addressing tribunal. बाहर नहीं है?
My lord, there is a problem that he has filed the return after the issuance of the show cause notice. And all returns has been accepted. No returns has been rejected by the What is the returns? Return is a version of books of accounts. When on the one part you are saying that he is not maintaining the books of accounts, on the other part you are accepting his returns. That is a contradictory of the
No, his returns are not been accepted. Who told you?
Yes.
That will come at a later stage.
That's a much later stage.
It's on the
Where returns accepted?
He
He
has-
filed returns.
he has
Filing is
filed-
self-assessment.
There is a 61, section 61 says a scrutiny of returns. He has submitted the returns and the returns has been accepted unless and until it has been objected by the
No.
proper
That will be
officer.
at a later stage.
That's a much later stage.
Filing does not
साढ़े
come
5 साल है उसके पास करने के लिए भाई.
But cancellation के लिए proceedings.
No, not even that. Returns are not accepted. It's your self-assessment you have done. You file the return. That's okay. अगर वो लिखविड जाता मैंने accept कर ली, even then it makes no difference. 70-74 is still available. आपका ASM रिटर्न में आपकी इंक्वायरी हो गई.
बाद में देता
आपका AS सुनो. We will not waste time on this. ASM रिटर्न आपको इशू हो गया. That
Question is for the cancellation of register.
मैं कैंसिलेशन की बात ही कर रहा हूँ. आपके जवाब आपके ASM रिटर्न इशू हो गया.
देखना है कि if he has filed the returns,
बस इसे फाइलिंग ऑफ रिटर्न नॉट एक्सेप्टेंस और नॉन एक्सेप्टेंस ऑफ रिटर्न. असेसमेंट थोड़ा कर रहा है उसकी. तो आर्थिक कैंसिलेशन की बात है. ओके नेक्स्ट बिल.
delay or pre-deposit.